Thank you so very much for the opportunity to be here. I'm grateful and blessed. So obviously Proposal 3 is so, the sort of gravity of what we're facing is just so extreme that I'm looking forward to these opportunities that I have throughout the whole state. Last Saturday I was in Kalamazoo, and just kind of mention, I think people are starting to hear about Proposal 3, and people are saying, well, are you kind of getting tired of talking about it? And I say, no, this is so important. We cannot speak about it enough. We want to make sure that we can reach everybody that we possibly can to let them know about the implications for this proposal. So as you know, this fall Michigan faces Proposal 3. This proposal is not just any abortion law that the voters will be considering. It is the most extreme ballot proposal we have ever faced, and likely the most radical in the entire country. Proposal 3 has the possibility to misdirect our culture for generations. It would allow unlimited abortion on demand through all stages of pregnancy, even up to the moment of birth, by creating a constitutional right to abortion and a number of other things. So how do we get here? Earlier this year, I think we've heard in anticipation that the Dobbs decision at the United States Supreme Court would overturn Roe. Planned Parenthood and the ACLU of Michigan launched the Reproductive Freedom for All petition drive to place a constitutional amendment on the November ballot. One impetus for this amendment was the fact that Michigan has a valid pre-Roe ban on abortion, sometimes referred to as the 1931 law or 1931 ban. And back in 1931, the state reiterated in its statutes what had long been the policy, and that was that all abortions were prohibited in our state at any stage of pregnancy except to save the life of the mother. Another way to word that, though, is that under the 1931 law, abortion remains legal to save the life of the mother. So then in 1972, Michiganders defeated an abortion referendum that was on the ballot to legalize abortion. So at that point in time, Michiganders resoundingly said no to abortion in our state. Yet shortly thereafter, just months later, the United States Supreme Court decided Roe versus Wade, which then legalized abortion across the entire country. So under Roe versus Wade, this 1931 law was not entirely enforceable, but it remained valid law and was poised to go back into effect once Roe was overturned. The law is now enjoined, which means that it is again unenforceable, and the lawsuits over this statute continue to play out in court. But it is fear over this law that is fueling Proposal 3, and I want to dispel some of the myths that you may have heard surrounding this law. So consider back into, those of you who can remember, back into the 40s, 1950s, 1960s, maybe even the early 1970s, right? So this was before Roe versus Wade, and our 1931 law was in effect. Women were not denied treatment for miscarriages or ectopic pregnancies. They were not being jailed for having miscarriages or ectopic pregnancies either. Women were not being prosecuted for having an abortion, right? So the other side is conflating ectopic pregnancy care with abortion. So one interesting note, Planned Parenthood's website up until about 8 weeks ago used to state, treating an ectopic pregnancy isn't the same thing as getting an abortion. Then suddenly this was removed from their website, perhaps because it no longer supports the misinformation and fear that they're trying to spread. Further, Michigan law has several definitions of abortion, all of which make clear that abortion does not include miscarriages. In fact, one of the definitions explicitly says that elective abortion does not include, quote, treatment upon a pregnant woman who is experiencing a miscarriage or has been diagnosed with an ectopic pregnancy, close quote. In addition to this, Michigan also recognizes women seeking abortions as victims themselves. There is case law, it's called In Re Vickers, if you'd like to look it up, that shows women who seek an abortion, or the case law decided that women who seek or obtain an abortion are not to be prosecuted. The law particularly applies to abortionists and those advertising for abortion. So yet because of this fear over the 1931 statute, Michigan has now become the epicenter of abortion debate across the country. Proposal 3 proponents spent over $8 million just to place this on the ballot. So they do not lack for funding. Michigan Catholic Conference, together with Right to Life of Michigan and a number of other pro-woman and pro-life organizations, have been collaborating to defeat this proposal, forming the official ballot question committee, Citizens to Support Michigan Women and Children. So commercials have been airing and will continue to air as long as the funding provides. The coalition is focused on public outreach, so they're also organizing volunteers to go door to door, make phone calls to registered voters, and to get signed up with the coalition, I'll have the website at the end here also, but it's support.miwomenandchildren.org if you haven't become familiar with that yet. The church is also specifically working on Catholic outreach and education, and I'm very grateful for this opportunity to be here with all of you today. We were created for such a time as this. And this is true. This is truly an all-hands-on-deck effort. So it's all hands on deck because Proposal 3 is a constitutional amendment. We're only going to get one chance to defeat it. Now is the time. MCC has provided parish and election materials. They're available on our website at micatholic.org. We as Catholics are working to spread the word about what is actually contained in the language of this proposal and its significant legal and moral ramifications. So I cannot stress enough that this is a constitutional amendment. The Constitution is our foundational legal document, trumping all other state laws. Once something is placed in the Constitution, it cannot easily be undone, and it cannot just be corrected. The errors, misunderstandings, and overreach cannot simply be amended by the legislature like they do with statutes. Right? The governor cannot dismiss constitutional provisions with lawsuits or executive orders. In amending the state constitution would require another vote of the people and is likely to remain for generations. So when it comes to our laws and the Constitution, words matter. So we're going to look at some of the details of Proposal 3 in just a minute, but I encourage you to read and understand the amendment for yourself. First, has anyone seen any vote no on Proposal 3 commercials? Wonderful. Does anybody recall what some of those messages were? Father? Yep. Any specifics? Yes.
Yeah, just that one with the guys in the kitchen saying this is really confusing.
Okay.
Yeah.
So it's confusing, it's too extreme. Does anybody remember some of the other aspects of those commercials? Parental consent is a huge one. And so some of those messages are talking about how we have laws currently in place that are likely going to be invalidated by this proposal. So since the Constitution is our overriding legal document, anything that does not comport with it will be invalidated as unconstitutional. So some of the coalition's commercials point out that if Proposal 3 were to be added to the Constitution, dozens, literally dozens of common sense regulations currently in law would be in jeopardy. This includes parental consent for minors prior to an abortion. Michigan, again, has case law requiring that only physicians may perform abortions, which is in jeopardy. We have an informed consent statute requiring a woman be provided information about the abortion procedure, be given an opportunity to view an ultrasound, and be provided a 24-hour reflection period to consider this information she's received before undergoing an abortion. This also is at risk. There are health and safety standards and inspection requirements for abortion facilities. The state ban on the gruesome partial birth abortion procedure, and the state also prohibits taxpayer-funded abortions in the Medicaid program. And there are many other provisions that protect women, children, and families. Keep in mind that all of these provisions were in Michigan law invalid under Roe. So even with all of these provisions in place, unfortunately, Michigan sees a high number of abortions. So the last report from 2021 showed just over 30,000 abortions that year in our state with all of these in place. Keep in mind there's 26 abortion clinics in the state. I want to point out that there were 26 abortion clinics before Roe was overturned, and today there are 26 abortion clinics in Michigan because our 1931 law has been enjoined. A hopeful note, though, is that this is in relation to 150 approximately pregnancy resource centers, Catholic charity agencies, maternity homes, and adoption agencies throughout the state that help pregnant women every single day. Some of you may have heard the cumulative number, 63 million reported abortions in the United States since Roe. Well, this summer we calculated what that is in Michigan. The result is a cumulative 1.5 million abortions in Michigan since Roe versus Wade. And is one of the reasons why defeating this proposal is so important. These 1.5 million children, over 30,000 abortions this past year. How many more will there be if there becomes a constitutional right to abortion with no way to limit or regulate it in our state? So now let's consider the proposal 3 commercials and messaging. Have anybody received any of the mailers or seen some of their commercials? Just a few. Does anybody want to shout out anything you saw? What is their primary message? Anything that...
Restore Roe.
Yeah, exactly. So their primary message is this just restores Roe. So far they're really just trying to frame this extremely radical amendment as restoring Roe in Michigan. However, when we look at the language, you will see that it will do much more than that. Interestingly, though, they never talk about their language or what the words of their amendment will do. They just simply rely on a few talking points, and only a few weeks ago actually put the language of the amendment on their website. Keep in mind a few things while we review this language. So Proposal 3 severely threatens parental rights and involvement. It will likely eliminate health and safety regulations for abortion facilities. It will allow late-term abortions and partial birth abortion. And it could negate Michigan's physician-only requirement. So we're going to look now at these implications and also talk about how we can refute that this would just restore Roe. This is the actual language that would be inserted into the Constitution. Voters will not see this language. Only a summary will be provided on the ballot. But this is the full language that would be inserted into the Constitution if this were to succeed. So we'll start with Section 1, Paragraph 1, the opening. Every individual has a fundamental right to reproductive freedom, which entails the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. Does that sound like it just restores Roe? We have a lot of other things that are thrown in there. But let's just start with some first, kind of general impressions. To me, this list feeds on the misperception that some aspects of women's health care are not currently available to women. So like prenatal care or miscarriage management or help for infertility, and that is simply not the case. But fear is clearly one of the tactics that's in use. This laundry list of so-called reproductive rights also dangerously puts abortion on par with legitimate aspects of pregnancy care and women's health. But abortion is not health care. Abortion is never the answer. Women deserve better. And this is where the church and community offer support and accompaniment and healing for those who have been impacted by abortion. There was a survey some years back of post-abortive women that found that 86% of these women would not have had their abortion if just one person had helped them. 86% would not have had their abortion if only one person had helped them. And now, thankfully, we have the Church's Walking with Moms in Need initiative, which is up and running. So into the specifics of this language, this first paragraph. Let's start with every individual. It's not defined, so what does it mean? It's actually very concerning that the fact that every individual is used. and is being provided without any age limits. So notably, those promoting Proposal 3 are also self-described as reproductive freedom for all. So by not providing any age limits, this will most likely include minors. Teens and even younger children would likely be able to invoke these so-called rights to reproductive freedom without parental consent or even knowledge. The language is conferring constitutional rights to adults and minors, to men, women, boys, and girls, for all of the categories listed. It's in the words, folks. They crafted these words. They chose to use every individual. Why not use adult if they did not intend to include children? The words matter. Next, I want to highlight the fact that this is open-ended, including but not limited to. This language is supposed to be defining a fundamental right to reproductive freedom, yet it remains entirely open-ended. What are they not telling us? Nowhere else in the state constitution is language used in this manner to confer an unlimited, undefined right. With this clause, we cannot fully know what we are voting on. Not one voter has any idea what additional reproductive right this will include in the future. Sterilization, an undefined term, yet providing a constitutional right to sterilization. This would likely include procedures to prevent pregnancies, but could also include gender reassignment surgeries for minors without parental knowledge. And there are no provisions for conscience protection for doctors or healthcare facilities. This is providing constitutional right to sterilization. Well, some people have questioned this, saying, how does that implicate gender transition? This is a broad constitutional right to sterilization. Some of the surgeries that reconstruct an individual's sex organs are inherently sterilizing. Cross-sex hormones and puberty-blocking drugs sterilize temporarily while the drugs are in use. So it's very concerning, and this is another way that Proposal 3 clearly goes far beyond anything permitted by Roe. Notably, Planned Parenthood also recently expanded its business model from abortion and contraception to include gender-affirming therapy, as they say on their website, to transgender, non-binary, and gender-expansive folks, including education, referrals, and hormone replacement therapy. Now we come to abortion. This would establish an explicit fundamental right to abortion in the state constitution. In and of itself, this language has the possibility to invalidate all existing abortion regulations and health and safety protections for women that we have in state law, with this constitutional right to abortion. Throughout the rest of the amendment, there are other provisions that bolster the fact that this will allow unregulated abortion up to the moment of birth. So I want to pause just a moment again to reiterate the danger of our state constitution explicitly providing these rights to reproductive freedom to children by failing to define the term individual. By including minors, not only would this create a fundamental constitutional right to abortion, contraception, and sterilization without parental knowledge or consent, arguably it could create a right to these things even against a parent's wishes, because this language could confer these constitutional rights directly to the child. One more item on this list to highlight is infertility care. Clearly our hearts go out to husbands and wives who struggle with infertility. But in this proposal, the term is undefined. This would likely provide a constitutional right to both ethical and unethical infertility measures. This could apply even if one intentionally sterilized themselves or underwent gender reassignment and now want to have children. It holds implications for in vitro fertilization. It would create an even greater demand for the creation, storage, and use of human embryos in the IVF procedures. It would also likely have implications for surrogacy. Surrogacy is when a woman carries a child, either of her own genetic material, but with IVF now, more often it's not of her own, in order to give birth and surrender the baby to the intended parent or parents as agreed upon. Surrogacy exploits women and commodifies children. And because of this, Michigan law has banned surrogacy contracts and payments for children since 1988. However, this ban would likely be invalidated by a constitutional right to infertility care. So we've touched now on how this impacts parental rights and some of the ways it goes far beyond Roe. Every section of the languages amendment is concerning. Yet I want to specifically highlight where some of those other key messages are found. Ironically, given the proponents' messaging, this language actually places women and girls at risk in more ways than one. For example, it would likely eliminate any meaningful health and safety regulations for abortion facilities. And so we'll talk about how this is. So the second sentence of that first section reads, or second paragraph, sorry, of that first section reads, an individual's right to reproductive freedom shall not be denied, burdened, nor infringed upon unless justified by a compelling state interest achieved by the least restrictive means. A compelling state interest, right? This gives the appearance that the state could regulate, and current federal law allows for the state to argue that certain interests, that the state has certain interests in protecting life. But this amendment would utilize a very different and much more restrictive definition of compelling. So located in section 4, the definition for compelling, it says a state interest is compelling only if it is for the limited purpose of protecting the health of an individual seeking care, consistent with accepted clinical standards of practice and evidence-based medicine, and does not infringe on that individual's autonomous decision-making. So regarding the clinic regulations, I want to go back out to that second sort of clause there. To meet this compelling interest requiring that it be consistent with accepted clinical standards of practice for abortion. The problem is that these standards are set by the abortion industry itself, right? One of such standards is the National Abortion Federation Clinical Policy Guidelines. So in the future, even if women decided certain health and safety measures must be met, if abortionists disagree and they do not fall within these standards set by the abortion industry, then the health and safety regulations would not be allowed under this definition of a compelling state interest. As an aside, as someone who lobbied for Michigan's current abortion clinic regulations, I can let you know that every time health and safety regulations or anything about clinic inspections to make sure they're meeting requirements or are clean, anytime that comes before the legislature, the abortion industry and Planned Parenthood come out and push very hard against that, opposing such measures. Notice too how this definition is connected by an and. All three provisions must be met in order for this compelling interest standard to be satisfied. Is there any law that would not infringe on an individual's autonomous decision-making? So autonomous means having the freedom to act independently, not controlled by others or outside forces, or being independent in mind or judgment or self-directed. This final clause here practically guarantees there is no regulation the state could put in place. Regardless of even what medical professionals may recommend, the state would not be able to regulate if the regulation infringes on that individual's own decision. So, lots of troubling aspects here. Moving on to the next one. The vast majority of Americans do not approve of late-term abortions or the partial birth abortion procedure. They find them abhorrent. Yet this amendment constitutionally provides for these in a manner far exceeding what was allowed under Roe. This proposal explicitly defines fetal viability in a vastly different from the current understanding, which was actually established by Roe. So fetal viability under the current understanding is to be when a child can survive outside the womb, sometimes in a neonatal intensive care unit, often with some sort of medical intervention like oxygen. So approximately 21 to 24 weeks gestation with the advances in medicine. But this amendment would define fetal viability very differently. So first it says the state may regulate the provision of abortion care after fetal viability in section 1, paragraph 3. And then if we look at section 4, we see what they mean by fetal viability. They say the point in pregnancy when, in the professional judgment of an intending healthcare professional and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus without the application of extraordinary medical measures. This definition of fetal viability requires that a fetus be able to survive entirely on its own outside the uterus without the application of extraordinary medical measures, and greatly pushes viability to much later in pregnancy than that previously recognized by Roe. After fetal viability, there would be a much shorter time period with which to even try to regulate, and ultimately allowing for late-term abortions. And this definition would not allow regulations to require care be provided to babies born alive following an abortion if they cannot survive on their own without extraordinary medical measures. And then we'll notice, if we go back to the first provision there, they then provide a vague mental health exception that ultimately allows abortion through all 9 months of pregnancy. So let's look at this a little bit more specifically. So it continues that the state may regulate after fetal viability, provided that in no circumstance shall the state prohibit an abortion that in the professional judgment of an intending healthcare professional is medically indicated to protect the life or physical or mental health of the pregnant individual. So here I've highlighted a couple of items. First is the infamous health exception you may have heard about from Doe versus Bolton, which is the companion case to Roe versus Wade. In Doe versus Bolton, they previously authorized abortion on demand even up to birth in federal law with this open health exception. In this provision from proposal 3, this health exception would allow a healthcare professional, which in state law includes a chiropractor, a counselor, a nutritionist, an athletic trainer, even a social worker, to indicate an abortion is needed for a woman's health, with no parameters. An abortion could be indicated merely to alleviate stress or depression in the latest moments of one's pregnancy. This health exception creates a loophole that would essentially negate any regulation the state could put in place post-viability. I just want to touch briefly on section 2. The state shall not discriminate in the protection or enforcement of this fundamental right. So one of the sort of keys with this is that if this were in this Constitution, the state would likely be seen as singling out abortion with its ban on taxpayer-funded abortion through the Medicaid program. So with this provision, the state would most likely be required to fund abortion and likely many of the other items in that laundry list above, treating abortion, sterilization, and unethical infertility measures as any other medical procedure. This language places women's health at risk in other ways. In addition to allowing the non-doctor healthcare professionals, as we saw in the previous section, there's also language that could entirely negate Michigan's current requirement that only physicians may perform abortions. So let's look at section 3. The first sentence focuses on the individual and has its own concerns, but I want to skip to the second sentence. Nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. So this sentence pertains to someone helping, aiding, or assisting with these reproductive rights. They cannot be penalized or prosecuted if the individual consented. Well, who is someone? Right, this is constitutional language. Any guesses?
Anybody.
Yeah, right? I mean, it doesn't say. There's no parameters for the aid or assistance that they're providing. This is constitutionally providing that the state shall not penalize, prosecute, or otherwise take adverse action against someone. So this could protect a grossly negligent doctor. A woman could be harmed or even killed during an abortion procedure, and this says that the state would not be able to take adverse action, such as investigate or prosecute the one who harmed her if she gave voluntary consent. Someone could also include a friend with no medical experience, opening the state up to the possibility of so-called back alley abortions, with the state unable to take any action against a person who aided or assisted if the woman consented. And that would negate Michigan law that requires only physicians may perform abortions. There is also a risk that school teachers, coaches, counselors, and others who bring a child to obtain an abortion would not be able to be held accountable so long as the minor consented. So overall, Proposal 3 is radical and extreme and must be defeated. It will provide a constitutional right to abortion, allowing for abortion on demand throughout the entire pregnancy, unregulated abortion, including late-term and partial birth abortions, one of the most extreme policies in the world. And it also impacts much, much more, as we saw with that laundry list in the first paragraph. It will obliterate parental rights. A constitutional right for minors to abortion, contraception, and even sterilizing gender transition procedures will likely override any requirement for parental consent or even knowledge, and other people, teachers, counselors, and coaches would be able to help your child exercise these rights without you ever knowing. This will likely require the state to pay for abortions and perhaps all the other reproductive rights listed so as not to discriminate in their protection or enforcement. This is truly an affront to women's health and places women at risk. It could negate Michigan's current requirement that only doctors may perform abortions and prevent any meaningful health and safety regulations. Proposal 3 goes far beyond what Roe versus Wade ever permitted. And again, I can't stress enough, this is all contained in a constitutional amendment. In one fell swoop, this language is set to repeal or invalidate dozens of existing laws currently governing our state and our way of life. So I encourage you to go all in. As I mentioned before, this is our chance. We're only going to get one to defeat it. And with the Diocese of Lansing, we have prayer, fasting, and almsgiving that Jenny will address in just a minute. But I want to share with you something that Archbishop Vigneron mentioned recently. He said, we may not all be called to do everything, but we are all called to do something. So I encourage you to commit to take at least one action. We don't want to wake up on November 8th with any regrets. We want to wake up knowing that we did everything we possibly could. So I also encourage you to sign up for the Catholic Advocacy Network. If you don't already belong to this, the Michigan Catholic Conference puts out a weekly email, usually on Fridays, to let you know what's going on not only in Lansing, but also sometimes items of interest to the church at the federal level. And we also provide action alerts. So if there's something that you can influence lawmakers on, if you're signed up for the network, you can just click a couple buttons and then send an email to your lawmaker saying, vote yes or vote no, whatever the message is for that action alert. Another thing I want to mention is we got to reach people. We need to make sure we get the word out there. And so if at all possible, there's donation envelopes in the back to donate to the campaign to help those commercials stay on the air and to meet other paid advertising needs. So I want to leave you with this final thought. Proposal 3 does not reflect the values of Michiganders when you really look at it. This would be a radical departure from life as we know it. And once people hear how extreme Proposal 3 is, they will vote no. We just need to make sure to get the word out there. Please help us to protect women, children, and families, not only to preserve our state, but also to prevent this extreme language from spreading throughout the country. So please share the word about the dangers of this amendment, share the information, vote no on Proposal 3, and I thank you very much for your time and attention.